Good morning. Happy Wednesday. We're happy to see everyone today, even though we can't see you. We know you're here. Welcome to the WR Immigration webinar on document training with respect to Form I-9. We're happy to see you today. My name is Kimberley Robidoux. I'm a partner at WR Immigration, and we have with us Michelle Harmon, who is an associate at our firm.
Hi, everyone. Nice to meet you.
WR Immigration, as some of you may know, we're a top-rated immigration law firm. We thrive on providing that high-touch quality assistance to our clients and our collaborators, and we also use our rapid technology. So as I said, Michelle and I are happy to be here today and talk with you about some of the documents and how to prepare the Form I-9. We know that there are probably a lot of questions. So if you do have any questions, please go ahead and pop that into the Q&A, and we will try to answer those as we go through the presentation and the discussion today. And if not, we will follow up with you after. So we want to make sure that we can answer as many questions as possible. And with that, I'm going to turn it over to Michelle to get started with first thing you need to know about penalties.
So we wanted to kind of initiate our discussion on the I-9s and discussing the penalties. So employers who violate the law may be subject to civil fines, which I'll go over in a little more detail in just a moment. Criminal penalties when there's a pattern or practice of violations, debarment of government contracts, court order requiring the payment of back pay to the individual that was discriminated against, and a court order requiring the employer to hire the individual discriminated against. So increasing enforcement. Is there an increase in I-9 audits in fiscal year 2023? So the expectation for fiscal year 2022, which just ended, is about 3,000. ICE spent March of 2022 until April 2022 catching up. And they plan to conduct more investigations in the future. We don't know quite yet how many. What we do know is that in fiscal year 2018, ICE agents conducted just about almost 6,000 I-9 inspections. This is the most recent year for which we have information. So the civil penalties, the rate of possible penalties is increased regularly, and the current rates are as follows. Paperwork violations in 2022 range from $252, which we don't usually see. We usually see a lot more. And the top range is $2,507 for the first offense for substantive violations or uncorrected technical errors. Second and subsequent paperwork violations are anywhere between 1,161 to 2,322. For recruiting, referral, and rehiring violations, the penalties range from 627 to 5,016 for the first offense for each knowingly employed unauthorized worker. Penalties range from 5,016 to 25,076 for second and subsequent offenses. In fiscal year 2019, ICE conducted, like I said, almost 6,000 inspections and reached $14.3 million in fines, penalties, and forfeitures. And for the criminal penalties, as mentioned, it's for where an employer is engaging in a pattern or practice of hiring, recruiting, or referring for fee unauthorized aliens. The penalty is up to $3,000 for each unauthorized alien, and up to 6 months in prison for the entire pattern or practice. When completing the I-9, it's very important to take into consideration the current version of the form. Only the I-9 with date 10/21/2019 on the bottom left corner of all pages is valid. The current version of the Form I-9 has an expiration date of 10/31/2022, but just recently, DHS announced that this version has been extended until the new Form I-9 is released. So who completes the I-9? Citizens, nationals, and non-citizens. U.S. citizens include persons born to Puerto Rico, Guam, the U.S. Virgin Islands, and Northern Mariana Islands. Nationals of the United States include persons from American Samoa, including the Swains Island. Groups that are exempt from completing the I-9 are grandfathered employees hired on or before November 7th, 1986. Casual domestic workers, independent contractors, providing labor where the individual is employed by a contractor, providing contract services. So for example, an employee leasing or temp agency, and for somebody who's not physically on U.S. soil performing work. So when do you complete the I-9? Section 1 is the employee information and verification section. It has to be completed on or before the first day of employment. And Section 2 is for the employer's review and verification. Section 2 has to be completed within 3 business days of the first day of work. So for example, if the employee begins work on Monday, you must complete the employer's Section 2 by Thursday. And then Section 3 of the I-9 is for updating and re-verification. Just make sure that E-Verify, if the employer's E-Verify, the employer still has to complete the I-9. And then the next slide is the list of acceptable documents. There are various documents that are accepted, but note that this is not a complete list of all the documents that are accepted. We typically advise to review the M274 handbook. You can find that on USCIS's website, and there's a lot of information about other documents that are also acceptable. Okay, so now I'm just going to go over some of the common issues that we see in I-9 compliance. So original versus photocopies of documents. The documents have to be personally examined. They have to be originals. Even for remote hires, webcam review is not permissible. You can designate an authorized representative to fill out the I-9. There's no need for a specific agreement, but you're still liable for violations. Also, a notary public can act as an authorized representative. There's no need to provide the notary seal on the I-9. Photocopies of documents are not acceptable, except for certified copies of birth certificates. So how does an employer know if a document is real? So use the reasonable test. A document is acceptable if it reasonably appears on its face to be genuine and relates to the individual presenting it. So you want to look out for signs of fraud. So for example, if the Social Security number has more than 9 digits, or the Social Security number begins with 000, 800, or 900, which are numbers that are not used. Okay, so now I'm just going to go over List A documents, which are documents that prove identity and employment authorization. So I'll go over expired permanent resident cards. This type of expired permanent resident card we don't see very often. Just wanted to highlight it. It's the permanent resident card with the sticker on the back extending the expiration date. This is a List A document, and no re-verification or update is required. And some permanent resident cards, the expired permanent resident cards can be accepted with a receipt for an I-90, which is the application to renew or replace. The receipt will state that it extends the card by a certain period. It's going to be either 12 or 24 months. 24 months is a new rule that just came out late last month. And this is an acceptable List A document that does not need to be re-verified or updated. And so there's also expired conditional permanent resident cards. They are accepted with a receipt of the I-751 application to remove conditions. The receipt will state that it extends the card by a certain period. It's currently 24 months. This is somewhat of a recent development. Previously, it was either 12 or 18 months. This is a List C document, and when it expires, it must be updated and re-verified. We always remind employers that, if the individual provides the actual permanent resident card, it does not need to be re-verified. So these are kind of just pictures of older permanent resident cards, just to give you an idea of what they look like. And these are even older permanent resident cards that we don't typically see. So another, type of List A document is foreign passport and I-551 stamp. Just kind of take a picture. Here's a picture of it, just so you know kind of what it looks like. This is considered a receipt. The passport will include either an I-551 stamp, which is the stamp that's in blue, or a printed notation on the immigrant visa, which is the picture on the right with the red circles. The passport information will go on the first 4 lines of List A of the I-9. The I-551 information goes in the next 4 lines. And the expiration date is 1 year from the endorsement or entry date stamped in the passport, which is usually on the adjacent page. Because this is a receipt, you have to update it when it expires. You would enter the number in red font under IV expires on date as the document number. And that's kind of the information I just provided on the foreign passport and I-551. So another List A document is most likely what you have all seen. It's the EAD or Employment Authorization Card. It's generally valid for work with any employer. However, there are some exceptions, for example, students, which we'll go over. These are typically presented by individuals who hold H4, L2, J, and E spouses, DACA beneficiaries, students, TPS beneficiaries, asylees, refugees, K-1 fiancés, citizens of Micronesia, Palau, Marshall Islands, withholding of removal, deferred enforced departure, VAWA, trafficking victims, and several other types of statuses. Let's see, the document the EAD card has to be unexpired. There's some exceptions, which we'll go over. And it has to be re-verified upon expiration. So this slide kind of shows you how to complete an I-9 for individuals with an EAD. And then we'll go over the EAD card and the STEM 180-day extension. An expired OPT EAD can be presented in the CO3B category with the Form I-20. The I-20 must be endorsed by the employee's DSO or the designated school official recommending the STEM extension. The employee must have timely filed the I-765, meaning that it was filed before the expiration. You should not request proof of this, but if you become aware that the application was timely filed, the extension is invalid. And the EAD is extended by 180 days from the expiration date. So this is kind of an example of how you would complete an I-9 for somebody who is on the STEM 180-day extension. So in section 1, the employee lists the date 180 days from the card expires. In section 2, under list A, you would enter the EAD in the document title field. You would enter EAD in the document title field, enter the EAD number in the document number field, enter the date 180 days from the card expiration date on the EAD in the expiration date field, and enter EAD EXT in the additional information field. To update section 2, for a current employee with a STEM OPT extension, you would review the employee's form I-20 endorsed by the student's DSO recommending the STEM, and you would enter EAD EXT and the date 180 days from the card expires date on the EAD in the additional information field. So for example, EAD, EXT, and then the month, day, and year. And then you must re-verify in section 3 the work authorization on the date entered in section 2. So with that, I will hand it off to Kim to talk about some other topics of the I-9.
Great. Thanks, Michelle. So as you can see, or maybe as you heard Michelle saying, the EAD cards are used for many different categories of work authorization. So a lot of different classifications, and not all of them have the same rules, so they can get rather complicated. We'll talk here about some of those general rules and a couple of the specifics, and we always want to direct you to some wonderful sources from the Immigration Service, the M274 Handbook for Employers, which is online. I recommend bookmarking that so that you can go to it when you have questions. That information does get updated periodically by USCIS. And even though it says that the version is November 24th, 2020, they do update the online version. So you can save a PDF. My recommendation is, if you at all can, is to bookmark it and use that to go back to it. There's also some information on I-9 Central. So some of these information and instructions that we're providing, some of you may have seen that there have been changes over time to time. Some of the ways that I-9s were completed in the past have evolved a little bit. And I would say, before you went and said, oh no, we did this incorrectly, check with an immigration attorney to make sure that, no, it's okay, or if something does need to be corrected. And I say that because the M274 has been updated over time, and some of the ways that document information was inputted in the past might still be okay, but it's not the way that USCIS recommends it today. So with that being said, let's talk about some of the EAD card specifics with the automatic extension. So there are some classifications of work authorization that have automatic extensions, and those are under the categories of A3, 5, 7, if you see them up in the top left-hand corner. And that category of work authorization classification is on the EAD card. You see on the right where the EAD card has a circle, the category is CO9. CO9 is probably pretty general in terms of, or one of the most common categories that we see. That's for an application to adjust status to a U.S. permanent resident. And it doesn't matter on which that application is based. It could be employment-based, it could be family-based, it could be lottery-based. It's an application to adjust status. So that's the category CO9. Only the categories referenced here on this slide, and also they're listed in the M274 handbook, are eligible for automatic extensions. And the automatic extensions kick in if the EAD card extension was timely filed before the current EAD expires. And the individual has to be filing an extension, meaning that the category that's on their code or on their EAD card is A3, then the form that shows their receipt for the extension should also reference the category A3, right? So those two categories need to match up. The one exception is for the use of the code A12 and C19, which are for TPS, those can be used interchangeably. So if someone has an EAD card with a category of A12, and then they come to you with a receipt notice or an extension of their EAD card with a category C19, that would be acceptable. And that's eligible for an automatic extension. So the automatic extensions had been for 180 days. And recently, the Immigration Service kicked that extension period up to 540 days. And the reason for that is because, as you may have noticed with some of your workforce, the Immigration Service got really behind in processing EAD cards, specifically for a lot of different categories. They do process as a priority the EAD cards for students. So we typically see the OPT and the STEM OPT EAD cards applications processed pretty quickly within a few months. But the other cards for EADs, classifications, could be anywhere from a few months to 12 to 14 months. So it can get pretty lengthy. So this automatic extension came into play whereby you would insert the information about the EAD card as a List A document. And then in the second field, where you're looking for the receipt number, you would enter the receipt number from the receipt for the extension of that EAD card. For the date of expiration, you would add either 180 days or 540 days. Now we're in that 540-day period from when the EAD card expires. So you're getting that additional period of time for your either new employee or continuing to work employee. And then in the additional information field, you're going to enter in EAD extension. Okay. Once that automatic extension period is up, you want to make sure that you reach out to the employee to provide you with documentation to show their continued authorization to work. And when they do so, you would update in Section 3, right? And when you re-verify work authorization in Section 3, you want to make sure that you're using the current version of the Form I-9. So let's say that you have an employee right now where you are in that extension period of time, but in March, their new EAD card is received, and they come to you, and at that point in time, we have a new version of the Form I-9. I'm just using March as an example. We might have it before then. We don't really know. But at that point in time, if there's a new version of the Form I-9 out, you'll use Section 3 on that new version. So you just want to keep that in mind and make sure you're using the current version of the Form I-9. There's also, since a settlement agreement was reached in November of 2021, there are some automatic extensions for spouses of certain workers. So those spouses are in E1, E2, or E3 dependent spouse status, or in L2 dependent spouse status. There's also the H4 dependent spouse status. For the E and the L spouses, that settlement agreement stated that they have authorization to work incident to status, meaning that they don't necessarily need an EAD card to prove their work authorization. The H4 dependent spouses do need an EAD card to prove work authorization. Okay. You can tell the categories. A17 is for E spouses, A18 is for L spouses, and then C26 is for H4 individuals or spouses, not the children. They can't work as much as we would like them to. They're not authorized to work. It would just be the spouses. And then with these individuals, you would provide, oops, I think one of my slides got messed up. So let me just go here. Right. So we'll come back to the spouses. I just wanted to reference for the EAD receipts for those spouses. Just you want to understand that their status may be extended as well for up to 540 days if they have an EAD card renewal pending, but their extension is limited by their authorized period of status. So if you have someone in EL or H4 status who have filed an EAD renewal, then you may be able to extend their work authorization up to 40 days, but no greater than their authorized period of stay as referenced on their I-94 document. And the I-94 document is what references their classification in the US. Okay, so for the EL and H4 dependents, just be careful because they do have some automatic extensions of work authorization in limited circumstances, but not always. Okay. So now we're going to talk a little bit about your non-immigrant workers. So these would be individuals in H status, L status, O, P, right, the letters of the alphabet. For these individuals, when you initially hire them, you would potentially complete List A, right, in Section 2, because they will provide a passport, an unexpired passport, plus an I-94 document to reference their status in the US and their work authorization. So an I-94 document can come in various forms, right? They look a little bit different. The one on the left, which looks like a little card, is typically issued at the land ports of entry. So if someone is coming in along the southern border or the northern border through CBP, or if they're coming in through the seaport, if they're on a cruise. The middle document is what is printed from the CBP website. All of the information for individuals when they enter the US and they're inspected and admitted, their I-94 information is input into the CBP system, which is uploaded to their website, and the individuals can print their I-94 directly from the website. And then this last document that we have on the right is an approval notice. So if you have an H-1B extension or an L extension, and you receive it, the individual receives an approval notice from the Immigration Service, the I-94 document is at the bottom of that approval notice. So as you can see, I-94 come in a bunch of different formats. So we just talked about the I-94 document. Caveat: as pretty as the visa stamp is in someone's passport, it cannot be used for I-9 purposes. So just a reminder, the visa stamp, think of it as a ticket to gain entry into the US. And then once that person is admitted by CBP, they receive that I-94 document. And the I-94 document is what shows their status, and for non-immigrant workers, their work authorization, right? For those who are in H or L or O status. So just remember, no visas. You don't need them for I-9 purposes. Okay, H-1B portability. This is for individuals who are in H-1B status, and they're changing employers to start working for the new employer in H-1B status, a change of employer, or sometimes called an H-1B transfer. In those circumstances, the individual may commence working for the new employer while waiting for the new employer's H-1B petition to be approved. So in that case, if the H-1B worker starts employment with a new employer before the new employer's H-1B petition has been approved, then the information, again, it would be the foreign passport and the I-94 document. But in the additional information section, the employer is going to add in AC-21 so that you know that it's based on a change of employer and the date that the change of employer H-1B petition was filed with the Immigration Service. You can also keep a copy of the I-797 receipt notice and or the FedEx notice to show when it was submitted, that petition to the Immigration Service. Once that H-1B change of employer petition has been approved, then you would re-verify the work authorization by completing Section 3 on the current version of the Form I-9. And you would be entering the information for the work authorization, which in this case would be a List C document, and that's the I-94 document. That will be down at the bottom of the approval notice. Okay. This extension is I just talked about is strictly for portability, right? Because an individual may actually start working before the H-1B extension has been approved, or change of employer has been approved. But you also have individuals who are in HLO status or E, who may have work authorization that is automatically extended for up to 240 days if the current employer files an extension for that employee before the current work authorization expires. So in that situation, the employer would update the Form I-9 by adding in the additional information section the 240-day extension and the date that the extension was filed with the Immigration Service. Once that extension has been approved, or at the end of the 240-day period, you would then update Section 3 of the current version of the Form I-9 with the individual's new work authorization expiration. We're also going to just touch, so those are some of the more things that we see when you're dealing with List A documents. And I know we have some questions here, and I'm going to try to get through some of them. There was one question about using the I-129S, which is a DHS document, can it be used for I-9 verification? The I-129S is for individuals in L1 status. And so their documentation that they would be using to prove their identity and work authorization would be a foreign passport plus their I-94 document, or they could potentially use their I-94 document plus a List B document. So the I-94 could be used as a List C document with a List B document, with such as a driver's license. But the I-129S would not be used for I-9 purposes. Okay, so quickly on the List B documents, which are the identity documents, right? These are the documents that show an individual's identity. So in the I-9 world, an individual new hire employee can show a List A document, which is either one document or sometimes up to 3 documents that shows their identity and work authorization. Or the individual may show one List B document to show identity plus a List C document to show work authorization, right? So it's either it's List A or B and C. So for List B, most of the documents that are typically seen by employers tend to be a driver's license or a state identification card. It has to have a photo as well as identifying information about the individual, and it must be unexpired when presented for purposes of completing the Form I-9. During COVID, there was a period of time in which expired List B documents were accepted with respect to driver's licenses, and that all depended on the state, whether or not a state did an automatic extension of the driver's license, or if the individuals had to apply for something to get an automatic extension. So the rules varied state by state. Employers were required by the end of July to go back and make sure that they had the appropriate documentation for List B if they had accepted an expired List B document during the COVID period. So that's something that if you haven't done, you may want to check and make sure that you're in compliance. Going back and checking that the List B driver's license doesn't apply to everyone. So just be careful with dealing with the COVID flexibility provision. Just a little unknown fact here. Michelle had stated that the list of acceptable documents, that's page 3 of the Form I-9, does not include all of the documents that can be accepted. And the American Immigration Lawyers Association Verification Committee went through the M274 handbook, USCIS's I-9 Central, press releases, and found that there were about 40 documents that can be accepted for I-9 purposes, but are not specifically listed in that list of acceptable documents. One of which is CBP issue documents. This is something that I hadn't known up until about a year and a half ago, that you can actually use a Nexus card, a Sentry card, global entry as a list B identity document, which I can tell you here along the southern border comes in handy sometimes because people might more likely have this type of document than something else. And then we'll move on to list C documents. So these are the Social Security card is a list C document. What we want to emphasize today, hopefully you all know, but just as a reminder, if an individual presents a Social Security card that says valid for work only with DHS authorization, or the old one said valid for work only with INS authorization, it cannot be accepted for I-9 purposes. It can be accepted for obtaining the Social Security number for payroll purposes, or for something that's not I-9, but this cannot be utilized as a list C document for I-9 purposes because it strictly says on it that work authorization from the government is needed. So just be careful when reviewing the Social Security cards. There have been instances where permanent residents have their permanent resident card, right? They're permanent residents, but they've forgotten or they may not have known that they could contact the Social Security Administration to obtain an updated card that doesn't have this restrictive language on it. So some of those individuals may still have the restrictive language on the Social Security card, but it cannot be utilized for I-9 purposes. You see the other employment authorization from Department of Homeland Security, right, under list C document and the list of acceptable documents. There's a lot of different documents that can be accepted. So naturalization certificates may be accepted as a list C document. For those of you who may have been in the I-9 world years and years ago, a naturalization certificate could be accepted for the I-9 for list A, but no, it's only a list C document now. A refugee travel document is a list C document. A reentry permit for U.S. permanent residents is a list C document. And as I had mentioned, there are many, many, many other documents that may be acceptable. They just keep updating and changing over time. And what I-9 training would not be complete without talking about discrimination and the discrimination provision specifically of the I-9 compliance. And the reason that we are going to bring this up today is because the Department of Justice's Immigrant and Employee Rights Division, which oversees the discrimination compliance for I-9 purposes, has been very active in the last few years. And unlike an I-9 audit, which is done by ICE, specifically Homeland Security Investigations, an I-9 discrimination audit that is conducted by IER can get pretty costly, very burdensome, and they don't really like to give in. So they're tough. So we always want to warn people, stay away if at all possible, and just ensure that you are doing the best that you can to comply with the anti-discrimination provisions in the I-9 process. So what does that mean? The biggest abuse that IER may see and that we've seen is it might be unintentional, and IER regulations don't differ between intentional or unintentional. So even if this is not your intent, it could still mean a violation under IER's provisions. But you don't want to engage in document abuse. So what this means is don't request documents before hire or during the interview. Now, there might be limited exceptions. If you ask the question, will you now or in the future require support or sponsorship? And the individual says yes, they do need sponsorship now or in the future, then they are not necessarily a protected class. And in that situation, you may be able to ask additional questions in order to determine what type of sponsorship do they need, what will be the involvement of the company? Okay, but that would be the only time where you could ask the individual or for documents or ask additional questions when you're in that interview process. Otherwise, you don't request documents, right? You also want to make sure that you're not specifying which documents that you will accept from the individual. And I know this can be kind of hard sometimes. Individuals might want to do what we call the document dump on the desk. So an individual might have permanent resident card, a driver's license, and an unrestricted social security card, and puts them all in front of you or on your desk, and they say, you choose. The best thing to do is say, nope, I need you to please choose. I cannot choose for you. And that might be around and around for a couple of times, but stick to it because it's really important that the individual know that it's their choice of what documentation to provide you. Also, don't ask for more documents than what's required. So if someone presents you with a list A document, you don't need to see B or C. In some, one of the things, especially if someone checks box 1 that they are in section 1, that they are a U.S. permanent resident, and they provide their A number in that field in section 1, you cannot request to see their permanent resident card to verify the A number. So if the individual checks that they're a permanent resident, but then provides you with a driver's license and unrestricted social security card, that's it. That's all they need to do for completing the I-9 process. And you would not want to ask for anything else. Also, don't refuse to honor acceptable documents. So as Michelle said, if something looks valid on its face, then you can accept it. You're not an enforcer. You don't need to act or, be like the government because they have more knowledge than most of us when it comes to fraudulent documents. But if a document appears on its face to be valid and looks like there's a photo, it looks like the person who is presenting it to you, then you've done your job in ensuring that document looks valid. Okay, so those are some things to just keep in mind with document abuse. For the discrimination aspects of it, right, it can be either citizenship status discrimination in hiring, firing, or recruitment, national origin discrimination, document abuse, which we just talked about, or retaliation or intimidation. So none of these are permissible and can get you into trouble with an investigation by IER. So you want to make sure that everything that you're doing is consistent and with compliance of the anti-discrimination provisions and the I-9 compliance guidelines. So over documentation, right? What do you do? If you are doing a self-audit and you notice that there are list A, B, and C are all filled in, you can make corrections in order to bring that into compliance for I-9 purposes. And again, you would want to discuss with your immigration counsel before you made any changes during a self-audit. But for this particular purpose, if you are in an I-9 investigation, Homeland Security Investigations doesn't care if you have multiple documents, but IER does. So you just want to make sure that you're paying attention to that. Next thing we wanted to just touch on are rehires and retention. So rehires, if you rehire within 3 years of the date the previous I-9 was completed, you want to go through this flow chart to see, is the individual, yes, you have. So is the employment authorization still valid? If yes, then you can update the existing I-9 in section 3 with the rehire information. If the employment authorization is not valid, then you want to re-verify in the current version of the Form I-9. If the individual was rehired more than 3 years after the first I-9 was completed, then you need to complete a new I-9. And then retention rules, right? Basically, when can you purge a Form I-9? Never, ever, ever purge a Form I-9 for a current employee. You always have to maintain the Form I-9 for a current employee. Once an employee has been terminated, then you can determine your purge date. So it's either 3 years after the date of hire or 1 year after the date of termination, whichever is later. And we have taken from USCIS a nice little worksheet if you want to use this to keep track. For those of you who have electronic I-9 programs, that should allow you to keep track of them in the system automatically. But if you're still using paper I-9s, you can use this handy little chart in order to keep that rule fresh, top of mind, because it can get confusing with what you need to do. Okay. And then how about corrections of I-9s? Well, it's never too late to make corrections if there are technical violations. If there are corrections that you're doing, if you have paper I-9s, you never want to white out, you never want to black out. You always want to make the changes and always initial and date the change so that the HSI can see what change was made by whom and when, right? That's really important. And for electronic I-9 programs, it's very important as well that the electronic I-9 program says who did what, when they did it, and how they did it, okay? And then you never, ever, ever want to backdate. That'll get you into more trouble, even if you're just trying to make sure you do the right thing. It's actually the wrong thing, so don't ever backdate. It's just better to initial and date with the current date. If the correction needs to be done to Section 1, only the employee can touch Section 1, and only the employer can touch Section 2. And then just the last thing I'm going to go through quickly is the COVID-19 flexibilities, right? So the Department of Homeland Security just released, about a week ago, that the COVID flexibilities for Form I-9, which allows for the virtual review of documentation for Form I-9 purposes, has been extended until July 31st of 2023. Please note that this COVID-19 flexibility is only in existence for employers that have employees who are working remotely strictly because of COVID. And it is if the whole office or company is working remotely because of COVID. If you have people working remotely out of your Santa Monica office because of COVID, they don't want to come into the office, but you have people in the Santa Monica office, then this flexibility does not apply. And you would need to make sure that you're completing the Form I-9 in person for that individual. And that might be through the use of a designated representative for the company, right? So just be careful. This COVID-19 flexibility is only for companies that are working strictly remotely because of COVID. And so there are actions that need to be taken once the workforce started to come back, that the whole workforce was working remotely because of COVID. And then as individuals came back, then the in-person inspection would be completed or conducted for the Form I-9. And depending on who's reviewing the new document or the document that the individual is presenting, will determine do you initial and date Section 2 of the Form I-9 because you're a different person who's now reviewing the documentation previously presented, or if it's the same person that completed the I-9 2 years ago, that's reviewing the documentation in person, then that individual can do the physical inspection and make the notation in the additional information field. Okay, so one of the reasons that this may have been extended until July 2023 is because the government is now going through a notice and comment period to hopefully put in place virtual inspection of I-9s. We're waiting to see how that goes. The American Immigration Lawyers Association just submitted our comment to that proposed regulation, and we'll see what happens as we move forward. But just know now that Forms I-9 need to be done with inspection review of the documentation, and the individual. So with that, I want to make sure that we get through some of these questions. Michelle, did you have any that you noticed right away? I'm just going to take a second to go through the document. All right, so we have, can we continue to complete I-9s remotely? We just talked about that, right? If you meet the criteria for the COVID-19 flexibilities, then you might be able to complete remotely. But if not, if you have somebody back at the work site, or if an individual is remote just because they're remote, then you do need to do an in-person inspection. And a lot of employers are now using designated representatives to help with that. And then how long can you hold on to I-9s? That is our document retention rule that we went over as well. Are electronic signatures acceptable? That really depends on how that's being done. So if it is just having an employee DocuSign the Form I-9, then no. There are strict requirements when it comes to electronic I-9s and when an electronic signature may be accepted. So we want to make sure that we check in on that particular situation. If that's something we're happy to look into that if you have additional information about what circumstance that might be. What is a process for remote hires if webcam is not acceptable? Right now, a lot of employers are using a designated representative, and that is actually loosened up a little bit. It could be a member of the employee's household. It could be someone that the company determines or builds a relationship with and says, you need to go to X. You have a relationship with a professional, an accountant or a bookkeeper, that will be the company's designated representative. Or you can have someone who is, like I said, a member of the household or a friend or a roommate complete the I-9. In that situation, you want to make sure that you have something in writing that provides instructions to the designated representative and the employee so that the I-9 is completed properly. And you always want to make sure that you can review everything before, if at all possible, the employee leaves that designated representative side in case there are any corrections that need to be made. Should we keep proof of identification documents provided? That's a good answer, and I realized that it kind of glossed over some of that. So to copy or not to copy, you can maintain copies of the documentation that's provided for I-9 purposes. You want to be consistent in keeping the documents for all of the employees for whom you complete the Form I-9. So in that situation, if someone completes it or provides a List A document, you would keep copies of the List A document or documents if there are multiple, and then copies of the List B and C documents. And do that for every single employee. If you adopt a policy today, then you can make a note to your I-9 file that, as of October 19th, 2022, the company's policy is to maintain copies of all documentation provided for I-9 purposes. And then you would keep those documents with the individual's I-9. Please note, though, that if you are enrolled in E-Verify, there is a requirement to keep copies of the certain List A documents, like a U.S. passport card, a U.S. passport, an EAD card. You need to keep the copies of the front and back of that document. And then only List B documents that have a photo on it are accepted for E-Verify purposes. There is actually a benefit to keeping copies of the documents that are presented by the individual, because if you ever are audited or you are doing an internal audit, if you have that document copy attached to the I-9, and let's say the person filling out, the company rep filling out Section 2 forgot to put California DMV in the issuing authorities field, you can write that in, initial and date it based on the information that is in the copy of the document maintained with the Form I-9. Here's again, physically see remote employee documents. The best way right now, absent a new provision from the Immigration Service for virtual I-9 review, is the designated representative. The link that should be bookmarked. There you go. It's the M274 Handbook for Employers. So we'll send out the slide deck to everyone after the webinar, and feel free to go ahead and bookmark that. Like I said, it's helpful, as well as I-9 Central. And if you participate in E-Verify, bookmark the E-Verify site as well. Question about C09P as in Paul has an extension of 180 days. Yes, you can essentially, for this automatic extension purpose, ignore the P and treat it as C09, which right now, up until October 26th of 2023, there's actually a 540-day extension period. And again, the difference between C09 and C09P for purposes of I-9 document review and verification, there is no difference. So I think we have time for one more. Are permanent resident cards considered a List A document? Yes, an unexpired permanent resident card is considered a List A document. If someone has an expired permanent resident card plus the receipt notice for an I-90 application for extension of that EAD card, those documents are used as a List A document. Can you request documents during the onboarding process after a signed offer letter has been received? So for purposes of completing the Form I-9, you can have the individual complete Section 1 no later than the first day of employment. And then Section 3 is completed within 3 business days of the first day of employment. So you can actually complete the Form I-9 in advance. If this question is talking about requesting documents, if somebody says that they require sponsorship, then you can ask some questions in that respect to help guide you in determining what kind of sponsorship is needed and what the process will be, so that you can provide your team with an approximate of, oh, this might take 4 to 6 weeks before we can get this H-1B employee work authorization, et cetera. So I see that our hour of spending time with everyone is at an end, and I know we didn't make it through all of the Q&A. We will work on providing the answers to those, as well as sending out the slide deck. And if you have any questions, we'll provide you information where you can direct those questions to us following your review of the slide deck, or just anything that comes up after that. So we want to thank you very much for attending the webinar, and we're really happy to have spent time with you today.